Hello everyone. USCIS recently released a policy memo on June 17th. So this is based on a court settlement. So in this video, what we look at is what is that new policy memo and what is changed from the past and what is now the situation. So to get started, let's look at the background, why this policy memo was released by USCIS. The fundamental reason is, about I think in 2018, right? There was a court case that was filed by IT Surveillance, which is basically a big IT services group organization that actually filed a lawsuit. I think two of the lawsuits, and in that they basically bundled about 33 cases together and put up a big case in multiple locations, and eventually that came out in favor of IT surveillance, and this is the kind of judgment they got, right? Uh, that USCIS has actually issued some policy memos without proper policy, rulemaking processes and all sorts of things. So based on that, and also there was another, lawsuit that USCIS should pay back money, and also overall, in a nutshell, right, what happened was after the court decision came out, there was an agreement or settlement that was done between USCIS and the IT surveillance, and this new policy memo is basically, something that came out after the settlement and what was agreed in the settlement, that they will do certain things within 90 days. Yeah. So this is what that whole background for this is. So now let's look at the first couple of things, right? So if you look at the first one, what they said was they will cancel the 2020 Neufeld memo. So this was part of the agreement. We posted an article on this in the past. So this is one of the, I've been we have been writing for H1B for quite some time. And in 2010, when this was released, this was a very big deal because it actually had a lot of requirements for employer-employer relationship. And when they were to client side, this is how the whole point of, client letters came to the picture, and all sorts of these things came in. So it's a very, very important one that actually got revoked. So this, they will not apply anything from 2020 memo, or which is popularly called as Neufeld memo, for some of them, some of you who may remember. And the second one they said is they also will cancel the 2018 memo, H1B memo, that was on contracts and itineraries. So this was after Trump administration came into power, and they actually put up this memo, and they put in a lot of requirements, itinerary, asking for day-to-day activities, and where they'll be positioned, and what days and what they'll be doing. I mean, this is a hassle actually if you're into IT consulting, right? So all of these were practically impossible for many of these players, and large vendors also had many denials. So essentially this memo is also cancelled now with this with this new ruling and the settlement, right? So two of the biggest memos that created majority of the denials are now gone. Now, what they've given is based on that. They've given some new guidelines, right? So this clause of what they'll consider for employer and employee relationship has been there for some time, but they were actually using that or. You see that, right? Meet one of the four things: hire, pay, fire, supervise, or control. And the USCIS was treating this as and that's where they were saying employer should control the work even though they are at the client side. Yeah. So now this is very clear that if any of these, one of these four things is there, then there is a employer-employee relationship, and they don't need to do anything else. So this basically takes out this is coming from the 2020 memo, guidance. Yeah. So there is no need to submit client letters or any documentation related to that. So what they will look at is basically LCA that was filed, and the job offer letter, right, that you got when you joined the company, or any agreement if that was done between you and your employer, basically tells what you'll be doing, how they will manage you, and all sorts of things. Yeah. So this will be considered for the employer and the employee relationship, and no need for client letters. And what they also clarified is there needs to be a bona fide job offer. What I mean, bona fide is nothing but a genuine job offer, right? So what they say is, when you actually file for H1B petition, the sponsor needs to sign under oath. Essentially they are basically signing under oath, and penalty of perjury is something that, okay, basically they're signing in, think of it under oath, and if they violate it, they can be fined and they can also go to jail. Yeah, anything can happen. So basically this tells that there should be genuine job offer, and it should be in special occupation, and they will not adjudicate. Basically, USCIS will not adjudicate the petition or basically make a decision on a day-to-day activities or any of these job duties in third-party locations, but they look at the job offer and look at that. So this is for people trying to actually sponsor a job for somebody. This has to be genuine. It cannot be like that there is no job and somebody does something that is not really legal, right? And okay, now the other aspect is contracts and client letters, right? So now there is no need for contracts or legal agreements, right? In the past, you were supposed to submit all the MSAs, SOWs, and client letters, all of these things. Now they're all gone. No need to submit any of this. But if you submit it as additional documentation, it's fine. They will use it, but they will not be the ones required as part of the regulation, or they will not use that to adjudicate that. And the other one is a non-speculative occupational non-speculative work, right? So this is also from the 2018 memo. This one was essentially telling that, okay, let's say I'm going to be working at a client for 3 years. You need to give me all 3 years worth of work details, that too in H1B special occupation. So this was the regulation that the policy memo that they passed. So now there is no need to submit any detailed day-to-day activities for all the 3 years or the entire duration of the petition, right? So USCIS you'll use whatever H1B job description or job-related information that employer has submitted for that, and that they will consider for that for the special occupation-related work. So they will not look at any other things. Employer may submit additional documentation, but it's not mandatory. They won't be judged based on that, and they will not ask for this kind of things. And also, one important thing, this does not really take away any standard requirements for H1B position. So the H1B position must meet all the standard regulatory requirements that were there for a long time. I mean, it needs to be a special occupation, all sorts of fundamental things, right? And somebody who's applying for that, the person also has qualifications, all sorts of things. You can't just file an application that is not meeting any of these standards, or offer a position that does not meet the special occupation related things. Now, the other bigger aspect is benching, right? I mean, benching is a common term that's used when you're not really working for a customer, right? Imagine you are a full-time employee working for Google or Microsoft. You basically are working for them full-time. There is no concept of benching. But if you work for an IT services company, then what happens is they are actually placed at clients, and there is a non-productive time. That's called benching. And benching is a concept, as a concept, is not allowed for H1B holders. And there is a reason for that, right? Because according to US, workers worker protections, benching is not really technically allowed for unreasonable amount of times for H1B workers. So the logic here is, imagine you're not doing anything and you're on bench and you're getting paid. I mean, you're not really doing any technical special occupation work when you're on bench, right? So logically, it makes sense that if you're on bench, you're not really doing special occupation work. So it's actually violation of terms for for H1B for H1B position that you are actually approved for. So that is the reason benching is a very important thing to consider. So now employees that's what they say. You need to be continuing to be working on that, right? Based on your original terms and conditions that were approved. So, and benching is considered a material change. So whenever your project is over at a client, then that's considered a material change. What it means is that you need to file an amendment now, so if there is going to be bench time. So it's going to be very tricky for some of these things coming in, right? So you need to file an amendment because if you're going to be on bench time, and you cannot keep somebody on bench for an extended amount of time as well, because this violates the basic premise of special occupation of H1B, right? So that's why benching is a tricky one, and this is something that they kind of given guidance, which was not really enforced properly. So this will be enforced now in the future, because this is actually now part of this. Memo. And the only exception for these are when you're on a medical leave, or having leave based on Disabilities Act. Now, what is the maximum duration on bench? This is actually, there is no official regulation or anything as such today. So it's up to the discretion of the of the USCIS on this, right? So you can't be abusing the system and being on bench, like let's say in a year you can't be in bench for 6 months. So so that's unreasonable, right? So USCIS will use their discretion, and if they find that you've been being on bench for way too many times or whatever, and if you see they're violating any of these things, they can issue a notice of intent to revoke or notice of intent to DI, NOIR and NOIDs. And also they can also issue both of these if you are not filing proper amendments or any of these for any of these changes. Right? So that's very important. And the other aspect is the revoking of H1B petition, right? So when, let's say, you filed an amendment, and in the past, they could go back and revoke your previous petition that was originally approved. So what this would do is basically you would lose the cap for that, and then you don't have a cap number, and all your previous work gets gone. So this one has changed now. So I mean, I wouldn't really call change, but they're saying that they won't really revoke the original H1B petition now. Um, unless in certain conditions. So let's say you file an amendment, they will probably deny or revoke that on. They will only consider that amendment or the new petition that you filed with changes, and they won't go to the original petition unless there is abuse by employers, right? For example, there is a material change. You move to a new client location, or you move to a new client and it's far away. You need to file an amendment, or your bench you need to file amendment. So if you're not following all of these things, and USCIS comes to know that you're abusing that, or not really properly managing that, then USCIS can revoke the original petition. Yeah? So this is something that they have actually clarified. Now the last couple of things are itinerary requirements. So this is something that's from 2018 memo, but also this is also in the regulation, that is, but it's very vague. And that's why USCIS said that as part of the court settlement, that they won't use this for decisions, and they will publish future guidance, right? So itinerary, the itinerary requirement is nothing but, let's say you're working in multiple locations, giving details of what you will do in each of these locations in a detailed manner. That's what the requirement is. It's in the regulation, but it's not enforced, and because it's very subjective, right? So that's why this is not going to be enforced until they actually come up with a proper regulation on this. Yeah? So that is the point on that. And the last one is, this is a funny, they are basically that short-term approvals were given even for like 1 day, and I don't know how they even gave for 1 day. This was something that was raised in the court case, and the attorneys, the judge gave guidance to, judgment telling that you can't do that without giving a proper justification. So now they have not really taken that out, but they may issue short-term approvals, but even if they give something like that, they will give explanation why. And most of the common reasons would be like LCA duration is short or whatever, but they can't really give shorter durations because there is no work, because you haven't submitted speculative work for or day-to-day activities or all these things for extended amount of time. So this is in a nutshell the entire policy memo. It's kind of very technical document, right? I mean, it's a 4-page document, but this is what it all means. And this is effective from June 17, basically the day that is effective. And this will be applicable for all the pending H1B petitions that are currently being adjudicated, as well as future petitions that are filed with USCIS. But what if you filed in the past and you got denial before that? It's ironic. There's nothing you can do, unfortunately, so you'll have to file again. There is no again approval of the past petitions. So only that were part of the actual litigation that are at ITSR, they were all reopened and adjudicated, but other ones will not work in that. Yeah. So that's about it, folks. I hope you really got an understanding of the new policy memo. Definitely do subscribe for updates. So we plan to give more updates on this. Thank you again for watching.